All right, everybody, welcome back to the House Committee on Government Operations and Military Affairs. We are picking up for the second half of our morning work on H 649 this morning. And so heard a number of things in testimony this morning. So I thought it would be good to have legislative counsel help remind us of some of the duties and the work of the Truth and Reconciliation Commission as it was set up, I think in Act 128 last biennium. And then we'll kind of go through some of the things that we heard and see what work we have ahead of us on the bill. So Damian, I think you were going to get started for us.
Great. Thank you. For the record, I'm Damian Leonard from the Office of Legislative Counsel. So I think before we get too deep, it's worth stepping back since not everyone here was involved in actually working on and writing the legislation, to just step back and talk about what the Truth and Reconciliation was established to do and what its powers and duties are, and then move forward from there into some of the questions that we're grappling with here, because I think that might start to give us more perspective as to how we can approach some of the issues that have been raised for the committee and some of the questions that you've got. So the legislature established in the intent that the Truth and Reconciliation had a couple of purposes. The first was to examine and begin the process of dismantling institutional, structural, and systemic discrimination in Vermont, both past and present, that was caused or permitted by state laws and policies. So not looking at private discrimination, looking at discrimination by the state. A lot of that came out of testimony about things like the eugenics program, the Brandon School, other state programs that had resulted in harm to individuals because they belong to a certain group that the state had identified as undesirable or something like that. So examining and beginning the process of dismantling to establish a public record of the institutional, structural, and systemic discrimination that have been caused or permitted by state laws and policies. You've already heard that purpose this morning. And then the third piece was to identify potential actions that can be taken by the state to repair the damage caused by that discrimination, the discrimination under state laws and policies, and to prevent the recurrence of such discrimination in the future. So that third piece is identify, not to craft remedies or implement remedies. And that was a really important piece of the discussion on the bill, was that the members of the committees that worked on this wanted to ensure that the legislature had a role, along with the governor, so elected officials had a role in crafting any remedies based on the report, because ultimately elected officials are accountable to the public in terms of what they pass, and they're going to hear from their constituents and so forth. And so particularly with questions, and all the way back to when this started, there were questions of things like reparations or other state programs. And the answer was, we want to make sure that anything like that goes through the legislative process and as public input and bills drafted and so forth. So that was one of the big pieces that came out of this. And the way that this all worked was the commission is designed to basically be an information gathering body. It's not given quasi-judicial authority to decide guilt or innocence or anything like that. It's intended to gather the information on those particular populations that were identified. And just for the record, those are individuals who identify as Native American or Indigenous, individuals with physical, psychiatric, or mental conditions or disabilities, or family members of individuals with those disabilities, Black individuals and other individuals of color, individuals with French Canadian, French Indian, or other mixed ethnic or racial heritage, And then in the commissioner's discretion, other populations and communities that have experienced similar discrimination caused or permitted by state laws or policies. So those were the groups that were specifically identified for them to look into, using a mix of public hearings, interviews, and archival research conducted by the commission. And that's set out in, if we go to 1 VSA 906, that's set out in the duties of the commission. So one of their duties is to establish committees in consultation with the populations and communities identified to examine instances of discrimination. The next is to determine with members of those communities and historians, social scientists, experts in restorative justice, and other interested parties at the commissioner's discretion, the scope and objectives of the work to be carried out by the committees they establish to look into these issues. The third is to develop and implement a process to fulfill those objectives. The fourth is to work with the committees and staff to carry out research, public engagement, and other necessary work to identify and examine the instances of discrimination caused by state policies, to determine the current status of members of those populations and communities, and then to otherwise satisfy the scope of work. And then the final couple of duties that they have is to work with the committees and staff to identify potential programs and activities to create or improve opportunities for or eliminate disparate experiences for those populations and communities, to work on educational programming around historic or ongoing instances where the state is discriminating. And then finally, to work in consultation with those communities and experts in restorative justice to ensure that their work is open, transparent, inclusive, and meaningful. So those are their duties. So they do have a duty to try to make sure that they're open, transparent, inclusive, and meaningful. They have a duty to try to research the history of state instances of discrimination against these different populations, and then to identify ways to both try to craft remedies. So that will be part of their recommendations in their reports. And their final report is due in 2027. If the language in this bill moves forward. Right now it's due in mid-2026. And then also to identify ways to educate people about it. So the idea being that if you don't learn about the mistakes that have been made in history, you're doomed to repeat them, I think is a way to paraphrase the committee's thinking from last biennium. So that was their general purpose. Michelle from the commission went over their powers that they have, studying, investigating, establishing an office if they wish, adopting rules, which, as for those of you who know the rulemaking process, it's time consuming. The committees wanted to give them that power with the understanding that it might not be used. And my understanding is the commission doesn't intend to adopt any rules regarding its process, and just to instead go with procedures. So rulemaking is like a 6 to 9 month process, very intensive review. And given their resources, I think our understanding is that the commission doesn't intend to pursue that at this point because they have other things to focus on. The working within that structure, one thing that we did give them as authority, and it's in existing law, and in section 909, was we gave them both the ability to access state records, even confidential information. And then required that they maintain the confidentiality of any confidential information or information that's exempt from copying and inspection under the Public Records Act. We also require that except as otherwise provided, information and records acquired by or provided to the commission that would in any manner reveal an individual's identity shall be kept confidential and shall be exempt from public inspection and copying under the Public Records Act. That is existing law. And then that the commission shall not include personally identifying information of any individual in any report that it produces without the express written consent of the individual. So in other words, in the reports, the information has to be anonymized unless an individual is given their express written consent. That's already existing law. So that was what passed 2 years ago. The exceptions to that are that information and records acquired by or provided to the commission shall be available to the public in an anonymized form that does not reveal the identity of any individual, and information or records acquired by or provided to the commission may be disclosed in a manner that would reveal the identity of an individual if that individual provides express written consent. And then in that law, we also provided for private interviews, which were discussed earlier this morning. So the commission already has the ability to hold those private interviews. What the bill in front of you does is clarify that that is an exception. It just adds clarifying language referencing back to the open meeting law and so forth. And then it provides that any other record or document produced in relation to an interview shall only be available in an anonymized form that does not reveal the identity of the individual. So in other words, when the recording of the individual is private and kept confidential, if the commission turns that interview into some other record or document, they have to reference it in anonymized form that will not reveal the identity of the individual. And then the final piece there is the commission is directed to adopt procedures and safeguards to ensure to the greatest extent possible that it does not conduct any interview, even a public one, in a manner if the interview will review the identities of individuals other than the interviewee without their express written consent. So as essentially if they're for public interviews that are available to the public, they have to ensure and provide safeguards to ensure that anyone else's personally identifying information. So in other words, if a person says, I was at that state institution with persons, with Joe Smith and John Doe, et cetera, they have to find a way to redact Joe Smith and John Doe's name so that those individuals are not revealed in any public record there, or find a way to prevent that information from coming out in the first place. If this is done at an open hearing, basically advising people ahead of time, don't reveal the names of other individuals who may have experienced the harm. So that kind of gives us a grounding with the Truth and Reconciliation Commission. And that brings us up to the current bill. So the current bill, the three things we've been discussing today deal with those exceptions to the open meeting law and the creation of possibly additional exceptions to the open meeting law and the addition of these groups, which are called affinity groups in the bill. We're going to, I think, reference them just as groups. And so do you want me to dive right in on those?
So what I heard this morning, and I'm looking for feedback from the committee on this, I think it's worth probably spending the time on the section on groups and seeing if there are clarifications that need to be made, and to hear what feedback Damien or recommendations Damien heard from the House Judiciary Committee. So I feel like that's probably a great place to start. And if we get through that in the time between now and lunch, I'd then like to just take a look at some of the other issues that we heard and see where the committee's at on the extension of the open meeting provisions that are similar to what's in Act 1 and the closed meeting, where I think there were some questions for Tucker. So let's start with the affinity groups, Section 10 groups, and hear that first, and then we'll kind of see how much time we have for those other issues and get back to it after our BA discussion this afternoon.
So really importantly with the groups, before we go into Section 10, is to note that Section 6 gives the commission the authority to establish these groups. So one of the concerns I heard this morning, and I want to be clear that I'm paraphrasing, and I hope I paraphrase this correctly, is that there's a concern that the affinity groups, because they have this confidentiality, could be used as a loophole to get out of open meeting law requirements. So you do have the ability in establishing these groups to set up safeguards there, such as providing that commission members could not participate, or that they need to contract with an outside group to facilitate the discussions, and that members and staff should not be part of the groups. So you do have the ability to set up that to ensure, if you're trying to channel your meeting law discussions into the sections on meeting law, you do have the ability to set up guardrails there to basically say, if we don't want the commission and the commission staff to do anything except sort of facilitate and give people the option, and then let the groups themselves be potentially facilitated by an outside social worker or someone like that who has experience in helping with this sort of restorative behavior, you could do that. I'm not saying this is what you want to do, but you can set guardrails in the power there. But that's the first piece. You've given them the power to establish groups. You can set whatever guardrails you want there. The next piece is getting into, and brings us to Section 10. And so within the meetings and sessions of the affinity groups, the first thing we've done is establish that they're confidential and privileged. The Judiciary Committee upstairs expressed, so the understanding is that these groups are intended to be support groups for therapeutic purposes, not to be part of the fact-finding process. And I want to be careful when I say fact-finding, because that sounds quasi-judicial. The intent, I'm just talking about information gathering process. They're intended to be an option that's given to people after that process based on the testimony we heard from the commission upstairs. Again, I'm paraphrasing other people's testimony. Just want to be clear that if I've misstated anything, I invite the other witnesses to correct me. So one of the things that the Judiciary Committee was concerned about is, well, what if someone reveals information in there that relating to things that a mandated reporter would have to discuss? Abuse of a child, abuse of an elder. What about potential future harm? Somebody says, I'm so angry, I'm going to go shoot that person. And that is a terrible example, but I'm just giving it as an example. So what we did is we looked at, so right now we have 2 mandated reporter statutes. There are 33 VSA 4914 and 33 VSA 6903, and those relate to child abuse and elder abuse, respectively. And then there's also sort of this common law duty that provides an exception to things like the physician patient privilege, where if a patient tells you in a therapeutic session that they're going to go and inflict harm on someone else, you have a reasonable duty as the therapist to inform someone that can prevent that harm. Another recent case was an instance with where an individual came into an emergency room. Their blood alcohol was 0.21, so almost 3 times the legal limit. They admitted that they had driven to the emergency room and then told the nurse on duty that they intended to drive themselves home. The nurse called law enforcement. And when the nurse was sued by the individual for revealing confidential medical information, the court eventually held that, yes, she did reveal confidential medical information, but it was covered within an exception that allows physicians and other medical personnel to reveal that information if it will prevent imminent harm to to a member of the public or the individual. And so the danger of someone driving home drunk in the middle of the night from the emergency room was averted there by calling law enforcement to prevent the person from driving home. So the proposal upstairs would be to first to add in language providing that, and right now I'm drawing on 24 VSA 1968, which relates to our community justice centers. So in a community justice center, if a person goes in there and reveals information relating to a criminal offense, they're protected from having that information relayed to law enforcement in an effort to get them to speak freely. That said, there are exceptions where there is a threat or a statement of a plan that a person may reasonably believe is likely to result in death or bodily injury to themselves or others, or damage to the property of another person. When the disclosure is necessary to report bodily harm any party causes another during the actual programming. And then where there's a reasonable suspicion of abuse or neglect of a child or vulnerable adult, and the report is made in accordance with our 2 mandated reporter laws. And then the final piece allows for a court to decide that the information was revealed there in an effort to avoid discovery during a criminal or civil trial. I don't know that we have to have that, but particularly the first one, threat or statement of plan, and then the third one, revealing reasonable suspicion of abuse or neglect of a child, were the 2 that the committee upstairs was interested in adding. And then the final piece they wanted to add was notice, so that when you agree to participate, you're provided notice. What you say is confidential. But the following information could be revealed. So information regarding a threat of bodily harm or abuse or neglect of an adult, a child or a vulnerable adult. And so those are the 2 pieces that they would like added to the bill to address that. It doesn't address larger questions about the affinity groups, but I think you can also provide clarity within either the enabling language, within the enabling language, that this is not actually meant to be an opportunity for the commission to meet.
Okay, Damien's brought up several things. I think the pieces around mandated reporting and making sure we're aligning and addressing the concerns that our House Judiciary colleagues have recommended, I think, unless the committee objects, I would say let's have Damien go ahead and include those recommendations in a draft that maybe we can see as early as this afternoon. The policy question that's really more in our wheelhouse is the one around specifying whether what level of participation, if any, commissioners or commission staff might have. It seems to me overly restrictive to restrict staff. I don't really know if that would be, because whether or not they're hiring a third party is, I think we could leave that up to the commission and their staff. I'm a little bit more interested in the idea of limiting or making it clear that the commissioners won't be meeting, that it won't be the commissioners that are involved in that. And that really makes it clear this is not a public meeting. There's not business going here. This is an activity that's being done to support people who may be coming forward, but it's not official business in any way whatsoever. And I wondered, maybe Michelle, if you, it was unclear to me when the commissioners were here whether or not they envisioned any participation of a commissioner in those affinity groups, or whether it would make sense for us to just completely keep the commissioners out of the affinity group.
I suspect that they are flexible, and I understand what you're saying is it makes sense for not having commissioners, because then you can't like even think about having a forum or having any kind of public meeting. That makes sense, but then also just for the budget, they might not be able to contract with someone, maybe a staff member could facilitate the first meeting or something. Hopefully at some point this support group would just be the support group in for themselves. But yeah, it makes sense.
Yeah, so Representative Chase.
For what it's worth, I feel like the purpose of the selection group is to choose the best people to run this mission. And I'm okay with giving them the flexibility and leeway to set up these groups as they, in their experience, feel is the most appropriate.
Representative Nugent.
I'm just curious about why the affinity groups are in the statute as a thing, as a power that the commission can exercise, just because, you know, I know in the nonprofit world, a lot of those groups are set up and it's not like a legal situation or structure.
So just realized I dragged my suit through chocolate chip here. Sorry. If I made a look there on camera, good, but well, dry cleaner is going to make a lot of money off it. So, thank you. I'm good. This is what I get for eating and testifying. So the commission had asked Representative Burrows to include that in the legislation. In looking at the legislation, there's arguably they already have authority in existing law to let me just pull it back up here. Take any other actions necessary to carry out the provisions of this chapter. That said, the affinity groups, you could arguably try to fit them into some of their duties, but they may or may not fit. So the idea was to give them express authority to establish the groups if they so chose, with the may language, because unlike a nonprofit, they're a creature of state law. So just like our municipalities, they only have the authority that we give them. And then if they act outside of that authority, that can be challenged by someone arguing that they're acting without right. So that's why it's included in the bill. It was requested, and the thinking was that there wasn't a clear authority in the existing law, so better to call it out than to be silent.
It's very helpful.
Representative Higley.
I still think it sounds to me like it's a little bit too open-ended at this point as well. You know, for the commissioners to allow for a group to get established, there's still no, you had mentioned that maybe a mental health therapist could run the group. I'm assuming that mental health therapist would have to be paid, right? Correct? So.
Right. So there is a budgetary constraint that Michelle mentioned. the commission has a particularly tight budget and limited resources, so there are some constraints there. So I think, one of the questions will be, if you set guardrails around it, is it going to impact other things? And I just want to be clear, I'm not advocating to add the contract with a third-party language. It's more of just suggesting a possible approach to address concerns that were raised this morning. And again, Michelle suggested another alternative approach. So there are some policy questions about where you set the guardrails and then what authority you give them, and whether that's going to be meaningful authority or whether we're just going to be adding words, but they're going to be, navigating them will be so difficult as to make it language that's adding a power that can't really be used. So, a lot of this is going to get back to the policy. I'm sorry to punt back to you.
Well, and then, Daniel, my understanding currently is those groups would have to be disbanded as of April 2027, correct?
So, that's a good question. When in drafting the bill, I hadn't considered them to be part of the commission. But I guess you could make that argument. So it may be, as you set guardrails around that, you could set up language just to clarify that they're not part of the commission, that their meetings are not, part of this process. They're just, establishing an outside group. I think the argument could be made. I certainly hadn't considered them to be part of the commission in drafting this, but one of the difficulties, as I'm sure you guys have run into when you're working on bills, is that you're working with the sponsor, and the sponsor and the attorney you're looking at it from the sponsor's point of view, and sometimes having that other perspective that comes in the committee process reveals things you never thought about.
That's why we're here.
So that's a good question. It's certainly clarity we could add pretty easily if you decide to keep the language in the bill as it moves forward, or some version of it.
Well, really, I mean, if it wasn't tied to that date, then there's got to be some funding that continues to go on after that to pay for mental health therapists and keep the.
Right. So.
So I am hearing kind of two perspectives, Representative Chase and Representative Higley. One is the one I am sort of inclined to focus on, which is our real focus with this bill is about the facilitating the ability for the commission to do its work. It asks for this additional power. We have a rather thorough selection process that we're reconstituting if we pass other sections of the bill. And then we've got the concern around, I think that's been brought up and in the background of much of the testimony we heard earlier this morning about the affinity groups being like another way for the commission to do business. I think we can at least completely address that by just making it very clear in the enabling piece that these shall not be meetings of the commission and not include a quorum of the commissioners. I think the details around, setting up a group and how they need to be staffed, if they need to be staffed, are something that I feel like we can leave to the commission. But as I say that, I wanted to ask council, in the discussion about the confidentiality, there was this question that I think maybe Mike Donahue had brought up around like getting around whistleblowers or allowing so the prohibition, the action that's allowed to be taken if somebody has privileged information revealed about them is about their privileged information, right? So if for instance, there was whether it was a therapist that was hired by the commission or just a staff person that was holding a group, if they did something inappropriate and somebody who was at one of those affinity groups revealed that, went to the state ethics commission with a complaint, they couldn't be retaliated against for that. It's really about the revelation of privileged information or who's participating, right?
Right. So there are a couple different things that are coming to bear here. One of the things that came up was would the confidentiality relating to the group discussions then extend to if that information was revealed as part of the commission's process. So I think that concern will, one, the protection extends to disclosure of information that's revealed in that meeting, and then revealing it in a way that harms the individual. Arguably, actually revealing that information during a public committee meeting could result in harm to an individual. So, but in the same way that posting it on your Facebook page, blogging about it, including it in a book that you're writing, all of these things could result in harm to that individual if you reveal that information that you only gained through participation in the group session. Part of the concern, I think, is addressed by excluding the commission from this because the commissioners participating would then be bound by the same duty of confidentiality. They already have a duty of confidentiality for the work they're doing as the commission, but it's qualified, it's limited. It's limited to not revealing personally identifiable information without express written consent. So separating the commissioners from these group meetings will address some of that concern about the confidentiality piece being carried over into commission business. The whistleblower concern is so I think there's a couple things there. So typically whistleblower protections relate to when an individual reveals information related to wrongdoing to a government agency or law enforcement. So for example, one of the whistleblower protections we have in statute relates to nurses who reveal that there was a failure to meet the standard of care at the hospital, and there are specific safeguards that allow them to testify. We've also provided something like that for teachers and for state employees. And then in addition, there's also in a lot of, say, our anti-discrimination laws and employment laws, where I spend a lot of my time, all of them have these anti-retaliation provisions, which say, if you report someone violating the law, you can't then be fired or have your pay reduced. In this case, I think what judiciary is talking about for these groups is basically saying, we'll keep the discussions confidential with the exception like we would provide in a therapy setting, where if you're revealing intent to harm or ongoing harm, we're going to provide that can be reported and that individual is protected. So they don't have to worry about getting sued for calling the police to say, they just told me that they have this plan that they're going to carry out to harm another individual or individuals. And then law enforcement can do its job and protect the safety of the public. But I do see the concern of if commissioners are participating and then they're bound by that confidentiality, you start to get into this really weird gray area where you have competing duties of confidentiality and so forth. So if you were to add language on the kind of, again, adding the guardrails around how these group sessions could be used, if you keep them in the bill, would potentially protect against that by preventing commissioners who are supposed to be gathering information as part of their commission process through the meetings, the research, the interviews, from being part of these sessions where people may say other things or, you know, share that, hey, I identify with what you experienced. Like, that's not meant to be an information gathering session for the state. It's meant to be a support session, as I understand it. So I think providing that guardrail would address some of Mr. Donohue's concerns about that, and also providing that commissioners aren't participating. So you again don't create the potential for a loophole in the open meeting law, thereby creating a completely confidential, you know, session of a public, where a public body could participate and then be completely insulated there without having the other guardrails around it that we've talked about with executive sessions and other things. So, and you know, I can't weigh in on these things or on the policy points here, but it's, if you want to insulate this, I think that goes in the guardrails, the enabling language.
Sounds like we can accomplish a lot by just saying the commissioners are not participating in the groups.
Yeah.
Okay, questions, Representative Waters Evans?
Thank you. So speaking on the section B, or letter B there, where it says a person who attended a community group session may bring a private action in civil division of Superior Court for damages resulting from a breach of the duty of confidentiality.
Yep.
That would apply from one member of the group to another member of the group, not just someone running the group or someone on the commissioner's staff, correct?
Yeah, so that would apply to, both participants and anyone running the group. So if they gained the information through that group and then breached that duty of confidentiality, they could be liable if it results in harm.
Okay, does that exist anywhere else in statute applying to any other kind of support group or, you know, I know it's not the same, but like if it was an Alcoholics Anonymous meeting and then I went online and published a list of everybody who was at the meeting, would that be something that someone could bring a civil action against me or?
Yeah, so we do have some examples from other laws, and Tucker may be better situated to comment on some of them, but I can comment on, for example, regulations around, for example, HIPAA, where
Right.
we have prohibitions on revealing patient medical information, including information that's disclosed in a therapy session that could relate to.
Right, but that's a medical professional with a person who is a patient, not if maybe a group of people who are in a therapy session. I guess the heart of my question is, is this here because it's not specified anywhere else? And so it's not, and should it be specified somewhere else is a larger thing, if not? And then my other question, maybe you can't answer that question about the should. And then my other question would be, is it because this is a state-run group or a state-sponsored group that makes it different from a private or you know, something that was put on by like a hospital or an individual?
Right. So there's a couple things here, and again, I may kick this over to Tucker to add detail. So one of the things that we looked at in putting this language together, so the sponsored requested that we provide protections for confidentiality. And one of the questions was, well, what happens if someone breaches that? So while there is a clear patient-client privilege or patient doctor privilege, or patient medical professional privilege under laws like HIPAA that protect against disclosure. The law is not as clear on what happens if it's a private individual who discloses that medical information. Some states have recognized that privilege, but my understanding is not all. And this is where I hand over to Tucker to give more of a detailed discussion.
So may I ask just one more question? Maybe you can address too. So would then putting this into this particular law, meaning it applies in other relevant situations? Like, could it be used as
No, it's limited to this group.
okay.
So I'll start from the top, just to say that there are statutory privileges and statutory duties of confidentiality that are similar to what is established here. There's also the sort of widespread common law duties of confidentiality that exist. So there are multiple sources where these duties can be found. We have several codified privileges. It's not just patient. There's, for example, marital privileges that can be asserted in court. You have primarily confidentiality and privileges based on the relationship between the two parties. So, for example, Vermont has a priest-penitent privilege and priest-penitent confidentiality. So, starting from there, thinking about it, there are common law privileges that have been established through decisions where even if it's not codified in statute, an individual can make the claim you had a duty to protect the privileged or confidential information that I was giving you based on our mutual understanding that this was private and the relationship that we have. You would not have gained this information absent this special relationship that exists between the two of us. They can bring a private right of action based on that common law duty of confidentiality. And, it was brought up earlier that this is essentially just codifying a tort that we're all familiar with, probably working in the legislature. So moving on to the subsection, the establishing the private right of action. Something that came to our attention, thanks to one of our colleagues doing a continuing legal education seminar based on some recent court decisions, is that courts sometimes will not recognize that you have a right of action based on a statutory duty unless the statute says, yes, you have a right of action to bring this case before a court and claim damages. So that subsection D had to be inserted to provide consequence for the breach of the duty of confidentiality established in this section. One of your questions earlier was, does this exist elsewhere in statute? Yes, it does. And I just happened to come across one doing some statutory revision review of Title 22 yesterday. You can sue a librarian for revealing your library patron records, which are confidential by law for any library patron who is 16 years of age or older. So there is a duty of confidentiality that is applied to a state officer and has a specific right of action for any person who experiences damages from the breach of that duty. These are not universal. One of the issues that comes up a lot is that confidentiality is established for a whole host of information and records that the state gathers from private individuals. You can think about the list of 260 plus exemptions in the Public Records Act. Probably not a lot of them that provide a specific right of action if the state reveals your private personal information to the public. So it was put here to ensure that an individual who is experiencing damages from another individual in the group or a staff member revealing their private confidential information, also under this privileged, to the public.
With that note, it's worth noting that all of these things are policy decisions for the group here. It's also possible to set up to do contractual things and things like that. So one of the questions I got upstairs was, how is this different from a confidentiality agreement? And the difference is that again, I speak from the employment context because that's where I do a lot of my work here with you, is when you have an employee sign a confidentiality agreement, there's contractual damages in there. So you're suing them for breach of that agreement. And there are different standards that you have to meet when you have a contract. You have to show that both sides gain something from the contract, and you have to show that the contract is reasonable in the employment context. When you create a duty in statute, you're creating an express duty. You don't have to show that there was a contract and a meeting of the minds and that both sides received what we call consideration, something for their participation in the contract. You can create these duties. And as Tucker mentioned, we've done that in a variety of instances in the statute, from medical information to information that you may share with a member of clergy when you're speaking to them, or information that you may share with your attorney, et cetera. So there are these different privileges we've created to protect people against having to testify as to information they've gained. And there are duties of confidentiality we've created too. One that I frequently work with is around the Department of Labor when people apply for unemployment insurance and workers' compensation. There are certain things that are in those that come up, whether it's medical information or personal information about your employment situation, that the department and other parties are required to protect and not reveal. So it's not unusual to create duties of confidentiality. The question is whether this is a setting where you think it's appropriate to create a duty of confidentiality. And then if the answer to that is yes, do you think it's appropriate to provide for a statutory right of action? Because as Tucker said, while someone can argue that they should have a right of action, the only way the legislature can ensure that that's the case is by putting it in statute. Otherwise, you run the risk that the court will read it and say, well, the legislature didn't say that. And when they're silent, we don't fill in the blanks to make a policy decision. We let the legislature do that. So, these are ultimately policy decisions. The bill in front of you proposes to allow these groups to be created, to create a duty of confidentiality, and then to create a right of action. If you keep that language, the Judiciary Committee has proposed that you amend it to allow specific exceptions for harm to others, and also to require notice so people know what they're agreeing to by participating. And then we've discussed the other pieces around creating a boundary between this and the commission's business.
Is there specific language we can borrow from other statutes about like attorney-client privilege or whatever, like, so that it matches? Yeah. I don't know what the exact is, something about stop a current crime in progress or prevent a future one kind of thing.
Yeah, so the language on, so a lot of the privileges, the exceptions are either set out in codes of ethical code, like for Tucker and I, we have a code of ethics as attorneys that is part of our professional license. We don't abide by that. We're subject to sanction by the state bar. And then the courts, there's a lot of common law about, so for example, with the medical, with the patient-client privilege, the court all the way back in 1985 in a case called Peck v. Counseling Service of Addison County recognized that if there's a reasonable belief by a therapist that or a medical professional that the individual has revealed an intent to harm someone else, they have a duty to disclose just the information necessary to someone who can reasonably stop that harm, law enforcement in that case, to the extent, and nothing else. So that just the information, this individual was in a therapy session In that case, they revealed that they intended to burn down the barn of their parents. And so and they did. But in that case, that was the thing, is the therapist was protected to the extent that they revealed that information to law enforcement. They revealed this to me. They said they plan to do it soon. I'm concerned that this is a genuine threat of action. The putting it in statute, the way we put it in statute for other things is to specifically just call out, and both HIPAA and then, like I said, our community justice centers have specific language saying when there is a threat to a person or property, or when there's a reasonable suspicion of abuse or neglect of a child or vulnerable adult. They do it slightly differently, but both of them provide examples that we could just pull from to create the language, and that would be the language that the chair requested I have ready by this afternoon. That's what I intend to pull from. It's just I'm not going to reinvent the wheel for this, at least not for the starting point. And then you can mark it up and amend it as you wish.
So based on this conversation, I think on the topic of the groups, we're looking at the next draft having the word affinity removed. So it's just groups. We're looking at in the enabling language in section 6, making it clear that the commissioners are not meeting as part of the affinity groups and not participating. And then including those pieces that you just summarized that were recommendations from the Judiciary Committee discussion this morning. Is there anything else on the groups that we want to talk about or questions?
How about the end date?
The end date. Thank you, Representative. You knew I was missing something. That's why I brought it up. Do you have a specific recommendation? It seems like the implication is, since the commission is hosting and creating these groups, that they would be contemporaneous with the commission. So I don't think that they would have like the authority to exist beyond that, even though it's not specified. But if it would be an improvement to make that specific, I don't know that anyone would argue with that. Representative Chase.
I would support perhaps tying an end date of support of the commission, but I don't want to in any way preclude the groups from continuing to meet if they so choose.
No, I don't think that's the point is if there's going to be staff that's there that's,
Right.
funded through us.
Right, I'm just asking that if we do put an end date to the support of the groups, that it's worded in such a way that doesn't say the group shall no longer meet or in any way preclude them from.
Still getting together.
Yeah.
Representative Hooper and then Mark Higgins.
Classic stupid question of the day. Is there a legal definition of the word discrimination that is being used here?
We do not define it in the statute here.
Anywhere?
And throughout our statutes, we typically say shall not discriminate and then list some other things. So that means that we're going back to the common understanding of the word discriminate. So in most of our statutes, we do define the term harass in our employment laws for purposes of workplace harassment based on a protected characteristic. We also do that in our public accommodations laws. We don't define discriminate by itself, though. So we could, but the general definition of it is to make an unjust or prejudicial distinction in the treatment of one person relative to another or a category of people based on a particular characteristic. So at least with respect to what we protect in law. So it, so, I mean, there's, what we're looking at here is basically, so basically treating people prejudicially or differently in a negative manner based on their membership in one of those protected groups that I mentioned earlier. So Indigenous or Native American individuals with a disability or who have a family member with a disability, the French Canadian, French Indian or mixed ancestry, and then finally individuals of color or Black individuals. Those are the 4 groups that they're supposed to look at discriminatory treatment within the state government. So differential negative treatment by the state in state policy or law.
Or anyone else that the commission deems
Right.
justified.
So, and that, you know, would have to be, they're gonna, you know, they can do that. That would be something that they would, a decision they'd have to make on the record. So that is, again, one of the things here is decisions of this public body have to be on the record. And so they would have to make that decision that we're going to look at this treatment of this group. So, you know, let's say that in their research on the eugenics practices and the eugenics survey, they find another group that's not mentioned expressly in statute. They could say, we're going to include this group because they share the experience of these other groups. And we think it's important to include them and not leave them out because they were also subject to sterilization or institutionalized against their will or had their families separated or something like that.
And what is that?
Thank you. Are we going to talk about that open meeting law exception part now, or are we going to save that for later today?
So we have 8 minutes.
Oh, that's
I
right.
just,
Sorry.
let me just make sure. So I'd say we're coming back to the groups piece. So let's put a pin in that.
Okay.
So I think on the specific language, this may be a quick discussion and maybe one that we need to wait. But on the specific language that is mirroring our Act 1 extension of the COVID era meeting authority, is that the piece that
Yes, I
specifically?
had some thoughts.
Yeah,
I'd
so
like to
go
share yours.
no, go ahead and please,
Of course I
if you can summarize those, and then if there's a lot of discussion we need to have, we can.
Given the fact that we are considering, you know, the General Assembly is considering those open meeting laws, is the bigger picture of them in other legislation right now. Is it possible to add a date to this at which maybe, I'm thinking specifically about the physical meeting location, or something like that? Is it possible to add a date where that would end, or to add some language that says that it would no longer be effective once other legislation is passed that makes that, do you know what I'm saying? Or just to say it expires at the end of the year. So hopefully by then we have other things that would apply to this situation.
Yeah,
You know what I'm
so
saying?
we've recognized a couple of times this awkwardness of the
Yeah.
fact that we've got this language here, and we kind of you know, since we took the lead on the temporary extensions last year, the Senate's taken the lead on the conversation and doing a lot of work on S-55,
Right.
is my understanding. So there's sort of there's a fork in the road here. We could say, all right, we're going to go ahead and say just the Truth and Reconciliation Commission, we're going to extend this for the life of the Truth and Reconciliation Commission. That's what's on the page, correct?
Yes.
I want to ask the committee, and we maybe don't have time for this whole conversation now, if it might make more sense to say, we all know that through July 1st, there is this existing authority, the ability to meet remotely. And that it would be better for us to consider that whole policy holistically rather than doing it one at a time for each commission and board and select board and every other public body. I'm inclined not to create one policy like this that's an exemption when there's this open conversation about the entire thing. And for the moment, for the next few months anyway, there's already this authority. But
I would agree with you 100%.
I want to open that up to the rest of the committee. Representative Chase.
I would support a broad and uniform policy.
Yeah, see,
I got a thumbs up from Representative Rupert. Am I reading that actually as the digital equivalent of a thumbs up and on? Thanks, Representative Rupert. So I wanted to ask Michelle if you.
That's great. Thumbs up. Thumbs up.
Oh, we got a little delay there from Jay. If we parked the question of the Act One authority for the time being, if the commission could participate in the discussion as we move S55 forward and how they'll fit into that.
That makes sense to me. We don't.
All right, so I think there seems to be consensus, and I want to make sure that I'm looking at the correct section here because I scrolled away from.
Okay, so that would be section 9 of the bill.
It's on page 9.
And then, right, so that would be section 9 of the bill coming out in a strike all amendment. That's the one that allows both the meeting. So, well, there's 2 questions actually in there. The first is remote attendance. And then the closed meetings, so the ability to close a meeting with a threat. And then the final piece in there is the ability of the commissioners to have deliberative discussions without having a meeting, a public meeting. So there's really, I think what I hear you saying is that you want to address subsections A, B, and C, which are the closed and remote meetings separately, or just the remote meetings separately, and you want to keep discussing the closed meetings and then the deliberations of the commission members when we get back this afternoon.
Yeah, I think what I'm hearing from the committee is there's consensus that the remote meeting authority, that we set that question aside and take that first. That would be just A and B, I think, if I'm reading it correctly.
Yeah.
But that C, the closed meeting, which we've talked about the distinctions there and why for this particular group's, this commission's work, it might be worth considering having closure. So I would say when we get back after lunch, we're going to have a little bit of committee discussion about some of the BAA work that we've been doing to try to check some of those boxes off. There's also a proposal that came to light this morning that's now on our agenda to talk with Cannabis Control Board's council about a couple of staff positions that they're asking for in the BAA. So we're going to switch gears to those things from 1 to 145-ish. When we come back at 145 on H649, before we have to go back up to the floor, I'd like us to look at the closed meeting and the deliberations. Those seem to be the biggest open questions that we haven't really been able to delve into with legislative council in this part of our work.
So for my purposes, does it make sense to send you back just the revised language on affinity groups, or a strike all also showing the removal of the closed meeting language at this point, and then leaving the other stuff, knowing that this is draft 1 of who knows how many?
I would say
What works better for you?
I think what works better is to incorporate the changes we've kind of gotten to consensus on in a strike all, and then we'll come back and work on the open sections if that's possible to do by this afternoon. I know that's not a lot of time.
I think I can get the strike all for you. The language might not be polished. I don't know if the editors can get to it, but at the worst, I'll get you an unedited draft with some rough language. And appreciate everyone's patience with any problems in the language.
I am anticipating this afternoon, we're gonna have a robust discussion. And that we'll hold off on considering a vote until potentially tomorrow afternoon, when I think we have some unscheduled TBD time, for exactly this kind of thing. So, I think I'm making the decision right now as your chair that we will not be holding a vote on this today, and we'll save a final markup if we can even get there for possible markup and vote tomorrow afternoon. So thank you, everybody, for great questions.